Joining us now is Harvard Law professor Alan Dershowitz. He is considered one of the world's best criminal lawyers and Israel's single most visible defender, having won the Begin Award this past December. A Newsmax contributor, he is the author of hundreds of published articles and 27 fiction and nonfiction works, including The Case for Israel and Rights from Wrong. And Professor Dershowitz, it's so good to have you with us here on Newsmax TV.
My pleasure. Thank you very much.
Well, you have very strong views about the Trayvon Martin case. Is justice possible for George Zimmerman, or has the media coverage destroyed the ability of the courts to provide justice?
Well, I think justice is possible, but not with the attitude of this particular prosecutor. This prosecutor says she's here to do justice for Trayvon Martin, and that's not the job of the prosecutor. The job of the prosecutor is to do justice, period, to let the chips fall where they may, and even to resolve doubts in favor of defendants. Remember, it's only the defendant who's on trial. Obviously, the victim, the victim's family, has interests in justice, but the only person on trial, the only person who has rights, is the defendant. And the entire legal system, the courts, prosecutor, the defense attorney, must make sure that there is justice for the defendant who was on trial. I don't think there can be justice for Zimmerman in the county where this case took place. I think it has to be moved to somewhere where the jurors will feel that they could come to either verdict without having to worry about their safety or the safety of their family. I think right now, if a juror were to vote for an acquittal, they would have to be concerned about what the implications would be. Would the new Black Panther Party put out a bounty on their lives? Would their families' safety be influenced? It's very important that jurors feel free to come to whatever verdict is the just one.
Now, will there be pressure on a jury to find George Zimmerman guilty of some charge, either to calm racial tensions surrounding the case or because of political correctness?
Well, I would hope that the judge would instruct the jurors, and the defense and prosecution would ask the jurors in the voir dire to make sure that none of them would be influenced by the fear of riots or demonstrations. You can't have a criminal justice system held hostage to the mob. There was a very scary article in the Daily Beast recently where some lawyer urged the defense lawyer in the Zimmerman case to please plead his client guilty to avoid riots. You just can't deal with situations that way. A defense attorney's job is to get his client the best possible verdict he can. And the justice system simply can't be influenced by outside mobs and outside pressures. The Supreme Court has held that repeatedly. Most of the cases in which they've held that, the pressures have been against black defendants in the segregated South in the 1930s and 1940s, but those same principles apply here too. You can't worry that there might be Rodney King type demonstrations or riots and let that influence your verdict as a prosecutor, as a defense attorney, and most important, as a judge or a jury.
Let's get back to Special Prosecutor Angela Corey. Last week you said that she doesn't have the evidence to file a second-degree murder charge, but she has not yet released all of her files. What makes you so certain that her evidence is, as you have said, quote, so thin that it won't make it past a judge?
Well, the first piece of evidence that we've seen is the affidavit by the police officer, and that affidavit doesn't even state the elements of the crime. If I had been the judge, I would have thrown the case out immediately based on that affidavit. It just doesn't state anything that would show that any crime was committed. She may have additional evidence that she's hiding, but that's not the job of a prosecutor. This isn't poker. You don't hold 2 or 3 cards down and then reveal them as the betting goes on. If she has evidence, she should reveal it. And by the way, she has an obligation not only to reveal evidence that suggests guilt, but also that suggests evidence. She's already withheld that. As far as we can see, excuse me, she was aware of the ABC and other photographs that showed bruises and bloody head on the part of Zimmerman, and that was not in the affidavit, and she did not disclose that information when she sought a second-degree murder information or indictment. Already that violates very important principles of fairness in law.
Now, do you believe that she should remove herself from this case?
I think she should be removed from the case. I don't think she should ever have been appointed for several reasons. Number one, when a special prosecutor is appointed, their job is to get Zimmerman. get Zimmerman. That's their one job. That shouldn't be the job of the prosecutor. Second, she has a terrible reputation in Florida for overcharging and being political and holding her finger to the wind and seeing which way the wind is blowing. Then she made that statement that she's seeking justice only for the family of Trayvon Martin. She should not be the prosecutor in this case.
Professor, this case has prompted a debate over justice and race in America. Is the media fomenting the race war?
I think the media and others are clearly interested in focusing on the racial aspects of this case. And I don't think this case is a racial case at its core. I think this is a very complicated case under the Stand Your Ground statute or under traditional self-defense. It's a subtle case. It's not obvious what the result should be. It's very fact-driven and fact-specific, and people shouldn't be rooting for an outcome before all the facts are known. They should be rooting for justice.
Do you believe that George Zimmerman should sue the media civilly if he's found innocent?
No, I don't think you sue the media. The media has its job to do under the First Amendment. The media has the right to be wrong. It has the right to act foolishly. I don't believe in lawsuits against the media. The media is a very important check and balance on the operation of prosecutors, defense attorneys, and government in general. So I don't think there should be lawsuits against the media. And in general, fortunately in our country, they don't succeed.
George Zimmerman's lawyers on Monday opened a new website aimed at controlling his side of the story. He already has a Facebook presence. In your view, is this a wise tactic, or does using social media risk turning the case into more of a media event?
Well, I think both. Today, it's very hard in a case that has such public attention not to defend your client in the media, but it has to be done in a subtle way. I'm glad that Zimmerman's defense attorney has essentially taken control over the media defense. It was a very bad mistake to let Zimmerman and his family do it without a consultation with the lawyers, which is why the first lawyers obviously could not remain in the case. The question is how you present your case to the media. Do you lay out your story in advance? Do you simply argue about legal principles and the presumption of innocence? Those are very, very hard questions, but you can't ignore the media when you have a high-profile case like this.
Now, pundits have heaped scorn on Florida's Stand Your Ground law because they say it encourages vigilante justice. At least 24 states have enacted Stand Your Ground laws. Based on what you know, were George Zimmerman's actions covered by Stand Your Ground? And in your view, is Stand Your Ground a law worth keeping on the books?
Well, the first question is his action covered? We don't know the answer to that because it depends who the provocateur was. If Zimmerman provoked the encounter, then he's not entitled to the Stand Your Ground law. On the other hand, if it was Martin who provoked the encounter, if Zimmerman's story is correct that Martin was blindsided, that Zimmerman was blindsided by Martin, then the Stand Your Ground law does come into effect. This is not a paradigm of Stand Your Ground law because literally Zimmerman was lying down. He couldn't be standing. He had no opportunity to run away or escape. The Stand Your Ground law itself is far too broad. It would apply in the following situation. Assume I'm driving some fancy car that can go from 0 to 60 in 2 seconds, and somebody comes up to my window with a knife, and I can have two options. I can take my gun out and kill him, or I can put my foot on the gas and escape. Under Florida Stand Your Ground law, you can pull out your gun and kill him because that's the macho, manly thing to do, not to run away. But I think most reasonable people would think in a situation like that, you should put your foot on the gas and run away and not take a human life if there's an alternative. So I'm not a supporter of the Stand Your Ground law as broadly defined. I think a Stand Your Ground law that says that you resolve all doubts in favor of your own safety makes a lot of sense. As Justice Oliver Wendell Holmes once said, rationality is not expected in the presence of an uplifted knife. If you think your life is reasonably in danger and you have no reasonable alternative, you should be entitled to act in self-defense. But if you have a chance to run away without any risk to your life, that's the option of choice in a society that values human life.
Now, the last decade has ushered in an expansion of gun rights legislation. In addition to Stand Your Ground, there are now concealed carry and no duty to retreat laws. What do you view as the legal ramifications of increased scrutiny on gun rights in response to this case?
Well, I think there should be increased scrutiny on gun rights. Most police chiefs, most law enforcement officials are not in favor increased gun rights that allow guns to be sold at flea markets without any checking, that allow guns to be sold to people who pose a danger. What we're seeing, of course, is a clash between a lobby on the one hand, the National Rifle Association, which represents gun sellers and manufacturers and gun owners and users, and on the other hand, people concerned about law enforcement. And the interesting thing is, as I said, many law enforcement officials are not in favor of the trend that we see toward unrestricted gun ownership. There is a right under the Constitution, under the Second Amendment, to have guns for self-defense and for family protection, presumably for hunting. But reasonable regulations of such guns are the essence of a free society. Charlton Heston once said that the Second Amendment is more important than the First Amendment, because without the Second Amendment, there won't be a First Amendment. He's just demonstrably wrong, because all through the rest of the world, we don't have the right of gun ownership, and there's still the right of free speech all through Europe and many other countries. So you can have free speech without guns, but the Second Amendment does provide for gun ownership, but it provides for it in a reasonable manner.
Professor Dershowitz, the jury hasn't even been sworn in yet. Any idea what kind of verdict they would reach?
I don't think a jury will reach a verdict of second-degree murder based on the evidence that I know. The elements of second-degree murder simply aren't there. I think the issue is whether or not there will be a verdict of either voluntary or involuntary manslaughter or a verdict of acquittal. Remember, in the Casey Anthony case, the Florida prosecutor made the same mistake this prosecutor made, charged murder. And the jury looked around and said, we don't see the evidence of murder, so they acquitted completely. And there's a risk that there may be an acquittal in this case, even if there is some justification for a conviction, if the charge is too great. And my fear is that the prosecutor has raised expectations. And if you raise expectations and then the jury lowers the expectations, that has the ingredients for a potential riot. And so I think the prosecutor has acted irresponsibly by charging second-degree murder in a case where the evidence just doesn't seem to support that verdict.
Okay, a couple more questions for you on separate issues. To get to our studio today, you had to pass the Occupy Wall Street demonstration, which is just now getting underway and beginning to grow. This is just one of many demonstrations around the globe today protesting economic disparity. What went through your mind as you passed the few demonstrators who you saw, and where do you draw the line between allowing free speech to occupy Wall Street versus their obstructing the liberties of others?
Well, I favor free speech, and I think that free speech has to prevail even over the convenience of pedestrians. What I worry about is that the Occupy Wall Street risks being taken over by extreme radicals. First of all, I think it was a terrible mistake to have the big demonstration on May 1st. This is May Day. This is the day the communists have long celebrated as a way of destroying capitalism. The symbolism is unmistakable, and it seems to me that many on the extreme hard left that don't care about America, that hate America, are trying to take over these demonstrations. I think it would be very important for those who have reasonable complaints about Wall Street, and there are reasonable complaints to be had, disassociate themselves with the May Day radicals and make it clear that they love America, that they're not trying to destroy the free market economy, that they're simply looking to make some improvements and changes. But I worry that these demonstrations turn into hate America demonstrations, they turn into hate Israel demonstrations, they turn into hate capitalism demonstrations, and it's very hard to control. Now, the state shouldn't be controlling that. That's what the First Amendment's about. But those who lead Occupy Wall Street ought to be careful about who they associate themselves with, because they will be judged by the most vocal and most radical elements that come to these demonstrations, not by their own more moderate approach. So I'm concerned that this could lead to what happened in Oakland and other parts of the country where radicals took over and engaged in violence and engaged in kind of hate America a speech, and that's a great concern.
Last question for you, Professor, is on the John Goodman case in Palm Beach County, Florida. One of the jurors that convicted the polo mogul, John Goodman, of DUI manslaughter last month now says he was pressured into finding John Goodman guilty. One legal expert has said if this juror is allowed to come back and say that he had second thoughts, then anyone who's ever thought twice about a decision could do the same. He could have heard or seen things since the trial that influenced him. So what are your legal thoughts on this issue? Is this juror's revelation a legitimate cause for a mistrial in the Goodman case?
Well, I think it's too early to tell. I think the legal commentator is wrong. I think that Roy Black, the lawyer, is right. What's needed is further inquiry. We have to begin to question the juror extensively as to what he means by a pressure that was put on him. Was there discussion of the wealth of the defendant in the jury room? Were there indications of prejudice on the part of the jurors? We have to inquire much more. I think the judge made a serious mistake by cutting off the inquiry simply by asking one or two questions. This requires further probing. If it turns out that he did have second thoughts only because of what he read afterward, that obviously would not be grounds for a new trial. But if he can produce hard information indicating that the juror process was in any way tainted or that he was pressured into voting a verdict that he didn't really agree with, then a new trial might very well be warranted. So we need more inquiry and more information.
Professor Alan Dershowitz, thanks so much for joining us on Newsmax TV today.
Thank you.